On this episode of Law Weekly, we discuss the lingering issues of conflicting court judgment and its impact on the polity. My guest is a senior advocate of Nigeria, Wahab Shitu. Also showing on the program, women judges of Nigeria gather for a workshop in the southeast state of Abia, discuss issues of breaking leadership barriers for women in the legal profession, plus a recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shuyeli. My guest, senior advocate of Nigeria, Wahab Shitu, says the lingering issue of conflicting court judgments is a sad commentary on the country's judiciary and again spotlights the need to appoint competent and sound lawyers to the bench. But I began the interview first with his comments on the decision of Justice Abdulmalik Joyce of the Federal High Court stopping the Central Bank of Nigeria from further releasing monthly financial allocations to the Rivers State government.
There is no way one can fault the pronouncement of the Federal High Court in this matter, because those pronouncements are consistent with constitutional provisions. This is a democracy that is governed by the rule of law. And as such, all actions of the executive, the judiciary, and legislature, and all other arms of all democratic institutions must conform with the prescription of the rule of law. We all know that no decision of a House of Assembly can be taken except by 1/3 of all members of the House. That's what constitutes a quorum under Section 96 of the Constitution. So for a four-member panel of the Rivers State House of Assembly to sit and pass the 2024 appropriation bill of the House, it clearly is an illegality. And I think what the Rivers State government ought to do is to regularize its operations in line with constitutional provision. We operate a democracy by the rule of law, not a democracy by the rule of the jungle. And here, a distinction should be made, clearly should be drawn from legal, prescription and politics. We are not here discussing politics. We are talking law. No one will be very happy to see that a whole state government is starved of funds. But the River State government without a remedy or an option. Rather than appeal this decision up to the Supreme Court, one would think that they should represent the budget. I mean, the government represent the budget to the River State House of Assembly.
To the full complement.
To the full complement of River State House of Assembly. So that the democracy is not endangered. I mean, democracy dividends and execution of vital government projects are not affected by this. So there's no way you can fault the decision as handed down by the Federal High Court. And if my own view is that even if it is taken up on appeal up to the Supreme Court, we are likely to still come by the same result. So I think the people of River State are entitled to democracy dividends, and they should not be affected by the current political beatbacks going on between contending elements in River State. So, but as far as law is concerned, I think the option is left for the governor is to represent the budget.
Let's move on now to another topical issue. The implication of courts of coordinate jurisdictions giving conflicting judgments. I mean, we've been down this road so many times. Why do you think that this continues to happen? And what would move us forward in terms of reform, that we don't go back to this issue of conflicting court judgments in our polity?
First of all, we all know that conflicting pronouncements by cause of coordinate jurisdiction reflect a sad commentary of the Judas. It creates confusion. It erodes trust in the Judas and raises integrity and credibility issues. It also allows disputes to be prolonged unnecessarily. So I think the Chief Justice of the Federation is addressing, happily, is addressing that problem. You recall that all the judges who who made conflicting pronouncements in the River States matter from reports have been summoned.
Yeah.
And I think they are likely to get their own perspectives for why they arrive at those conflicting decisions. And if it is discovered that any of them, deliver any of those judgments in violation of settled legal principles, appropriate, disciplinary measures will be taken. I particularly frown at it. And I think every decent lawyer ought to frown at it. And the way out is to ensure that those who are appointed to the bench at various levels are people who are highly knowledgeable, people who are also principled, and people who have a track records of making pronouncements without fear or favor. So if there is no evidence of interference in the workings of the judge, and I think we have to sound a note of warning to the political elite to allow our judges to do their jobs, devoid of interference, devoid of undue influence. Because if they don't allow them to do their job the way it should be done, they are not only endangering democracy, they are also endangering the application of the rule of law. And the consequence will be anarchy.
I like the fact that you brought in the executive, the influence of politics, because a lot of the times when we see these conflicting court judgments, it's usually on political cases, and which calls into, as you have rightly said, the interference of politicians in some of these cases. But a lot of people say that we might not get a solution easily if the politicians are still involved in the appointments of our judiciary, because you talked about appointing people that are credible, people that have integrity, people that have a track record into our judiciary. But if we still have the president determining who is appointed as CJN, granted, we follow seniority, but if we still have the president appointing, we still have state governors who would have to sign off then with the legislature before, appointments and confirmation, that we might not get away easily from this issue of conflicting court judgments.
Well, the process can certainly be improved upon. But if you look at the present arrangement of appointing our judges, all the three arms of government in some way are involved. For instance, a governor appoints subject to the recommendation of the NJC, and they're also subject to the ratification of the various houses of assembly or the Senate in appropriate cases. So this mechanism ensures that all these three arms of government are involved in the appointment process. But the process can be strengthened by ensuring that there's a lot of background checks carried out before these appointments are made. And we should ensure that as much as possible, opportunities are, enlarged to enable as many, legal practitioners qualified as possible to apply. I'm particularly in favor of, and why not appoint from, not just those who rise through the ranks. You can draw a pool of judges from the academia. You can also draw from the body of senior advocates. What should be paramount is integrity, is credibility and knowledge. Because a corrupt judge is a danger to the system. More dangerous is a judge who is also ignorant. By ignorance, I also mean that if you are not up to date with legal principles as they unfold, even if you are brilliant and you know the law, you must constantly research the law in order to be able to apply up-to-date legal principles. So I think it is not just the duty of the judges alone. Even practitioners must ensure that they assist the judges with by citing up-to-date judgments, so that we can enhance the quality of our judgments at various levels.
Do you think that we'll ever see a day where lawyers would be appointed, senior lawyers would be appointed straight to the bench? Because even the judiciary itself is suspicious and does not appear to want to see, they prefer, those who have been queuing to continue to be elevated rather than see other people coming to the bench. So do you think we'll ever get to that time when we would have lawyers come to the bench straight from the bar?
I think the advocacy is on the rise. It's not a question of some people being curious. The administration of justice is our collective enterprise. Judges on the bench will take ownership. Academics will take ownership. Senior lawyers, members of the inner batch will take ownership.
Who should be leading it?
I think it should be, we have the NJC, for instance, National Judicial Council, and all the stakeholders should lead it. I think there should be some kind of conference on this, stakeholders conference, to really debate some of these issues. There is no particular, particular segment that is foolproof in terms of criticisms. If you say appoint judges from only those who rise to the ranks, some might find justification in that. There are some others who also criticize it and have valid reasons to say, okay, it is not in all cases that you find people who are necessarily the best materials, imagine it, eventually, in terms of promotion. And then, so there are the merits and demerits of each of these. But I think what is important is to identify elements who are integrity driven with sound mastery of the law. I recall that some of Idigbe, for instance, Mr. Anthony Idigbe said he had the intention.
Yes, even Olisa Agbakova SAN had interest in going
you
to
can hardly fault these two gentlemen that we have mentioned in terms of knowledge of the law, in terms of integrity. Even the practitioners, those who practice the law, we know ourselves. We know those who many who can be that you can vouch for in terms of integrity, credibility, and knowledge.
Let's round off with a kind of agenda setting for the Chief Justice of Nigeria. She's quite new in that position. And we've talked about conflicting court judgments being one of the issues, and rightly so, she has stepped into it and is addressing it. Senior lawyers will tell you that when they file appeals, they're not even setting up when they will get dates for it to be argued, maybe 3 years, 4 years from now. But, in terms of agenda setting for the CJ and what you think that she can do to fast track justice in the country, what are some of the things that you would advocate?
Well, I will summarize it in terms of agenda setting into two broad themes. In terms of people, it's about the people and about the process. Now, if the CJ and other stakeholders, because the CJ cannot act alone without the cooperation of all other stakeholders, ensure quality in terms of judicial appointments. And that's about people. And when we are talking of quality in terms of judicial appointments, we are also talking of quality in terms of personnel who assist the judges in the dispensation of justice. And quality in terms of members of the bench who advocate before our various courts. It's about the people. So, people who operate in the justice delivery sector. And when I'm saying people, I mean all the stakeholders.
The support staff.
The support staff in the justice delivery system must emphasize integrity. Must emphasize trust. The activities must engender confidence. And they must be ready to support the system in terms of attainment of justice. But apart from the people, the process. Now, we must ensure that the justice delivery system is fast-tracked, avoid elements of delays in the administration of justice, ensure that our rules or procedures in various courts are adhered to strictly, and where we need to make improvements in order to fast track the process, we should do that. So if the Chief Justice of the Federation, for whom I have a lot of respect and a lot of confidence, a lot of expectations from a lot of people, and I want to just pray that God assist her, His Lordship, in meeting up with those expectations.
And same for the AGF, the Attorney General of the Federation.
Yeah, the Attorney General of the Federation.
Yeah. So a lot of people are expecting a lot of reforms.
The Attorney General of the Federation, Prince Lateef Fagbemi, first-rate lawyer, experienced, and somebody who has seen it all. So for the first time, you have the bench and the bar being spearheaded by elements that many people consider credible and who are ready to work for the judiciary in terms of reforms, in terms of initiatives. So I think a lot of improvements, given this collaboration between these two, the Chief Law Officer of the Federation and the number one Judicial Officer of the Federation, and supported by elements who are also equally credible, willing to assist. We know that the narrative is likely to change. I'm optimistic that it will change for the better.
Thank you very much. Away from that interview and in Abia State, the Governor Alex Otti has admonished women judges to identify practices hindering the rise of women to leadership positions in the legal profession in Nigeria. He spoke alongside the Chief Justice of Nigeria and other speakers at the Southeast Zonal workshop of the National Association of Women Judges with the theme Breaking Leadership Barriers for Women in the Legal Profession, which held in Umuahia, the state capital. Dr. Otti said Nigeria must begin the journey towards building a legal system that encourages young women to dream big.
The theme of this workshop, Breaking Leadership Barriers for Women in the Legal Profession, invites us to come together and shatter the glass ceilings that limit the ascendancy of women in leadership positions in the legal profession in our country. I can make bold to say that we have a golden opportunity to look into the entire architecture of the legal system in the country and identify policies, practices, and conventions that, even when well attention, can become very strong obstacles to the rise of women in the profession. My expectation is that at the end of this workshop, we must have identified clear-cut measures that will make it easier for highly qualified women in the system to progressively climb and ultimately reach the zenith of their careers like the CJN.
The Chief Justice of Nigeria, Justice Kudirat Kekere-Ekun, who declared the conference open, and the Chief Judge of Abia State, Justice Lillian Abai, enjoined women judges to explore strategies to overcome barriers and shatter the stereotypes.
In order to positively impact policy making as it affects women in the legal profession, not only in Nigeria but globally. Key points of discussion centered on mentoring, self-development, policy, work-life balance, and dismantling intra- and intergender issues. I am therefore assured that this workshop will also be insightful, impactful, and illuminating, as the topics and very eminent speakers have been carefully selected with a view to generating very robust discussions and the cross-fertilization of ideas. We look forward to your active participation as we deal with the pervasive challenge of the glass ceiling that hinders the advancement of women in leadership roles within the judiciary and the legal profession. Let us explore strategies to overcome the stereotypes and dismantle the glass ceiling. Let us discover new ways of empowering women in leadership in law and chart a path towards a more inclusive and equitable legal landscape where meritocracy reigns supreme.
This workshop is geared towards training and mentoring young women lawyers in handling the various challenges associated with work and health in aspiring to leadership positions in the legal profession. It is expected that this workshop will positively impact the lives of participants who have withdrawn from the bar and the bench. To all participants, which include judges, magistrates, members of the National Federation of Women Lawyers, African Women Lawyers Association, all you're welcome to Abia State.
And just before we go, here's a quick recap of some of the top stories we're tracking at the court.
We begin with the report that the Court of Appeal in Abuja has reserved judgment in an appeal filed by the Indigenous People of Biafra, IPOB, challenging its proscription as a terrorist organization by the federal government. A three-man panel of the court, led by Justice Hama Barka, adjourned the case for judgment after the federal government and IPOB, through their respective lawyers, adopted their final briefs of arguments. IPOB is asking the appellate courts to set aside in its entirety the decision of the late former Chief Judge of the Federal High Court, Justice Abdul Kafarati, which on September 15, 2017, outlawed its activities in Nigeria. Justice Kafarati specifically declared as illegal all activities of the group, particularly in the southeast and south-south regions of the country. Counsel to the federal government has, however, asked the court to dismiss the appeal. Another panel of the Court of Appeal Abuja has also reserved judgment in the 6 appeals involving the emirship dispute in Kano State. The 3-member panel, led by Justice Mohammed Mustafa, reserved judgment in the chieftaincy appeals to a date to be communicated to the parties. Arguing the appeals, the counsel to the Kano State government and the State Assembly asked the appellate court to allow the appeals, while counsel to the respondents asked the panel to dismiss them. The appeals before the appellate court are Alhaji Aminu Ado Bayero versus the Attorney General of Kano State and 10 others, an appointment of Emir between Kano State House of Assembly and another versus Alhaji Aminu Dan Angundi and 6 others. On May 23, a federal high court in Kano, presided over by Justice Abdullahi Liman, had nullified Governor Abba Yusuf's action of deposing Emir Ado Bayero and appointing Muhammadu Sanusi II. Away from the appeal court, Justice Emeka Wite of the Federal High Court Abuja has adjourned hearing in the alleged money laundering case brought against the immediate past governor of Kogi State, Yahaya Bello, by the Economic and Financial Crimes Commission to January 21, 2025. At the resumed hearing, counsel to the EFCC had indicated his readiness to proceed with the case. The counsel asked the courts to enter a plea of not guilty on behalf of Mr. Bello in absentia. Bello's lawyer, however, opposed the move, citing a prior court order that requires Bello's fiscal arraignment before any application. Justice Emeka Wite adjourned the case for ruling on the EFCC's application and dismissed Bello's request to halt proceedings due to a pending Supreme Court appeal. Another judge of the Federal High Court Abuja, Justice Joyce Abdul Malik, has asked the Central Bank of Nigeria not to release any other monthly allocations to the Rivers State government. Justice Abdul Malik held that the receipt and disbursement of monthly allocations since January this year by the Rivers State Governor Siminala Alai Fubara was a breach of the Constitution, an aberration that must not be allowed to continue. The judge held that the presentation of the 2024 budget by Fubara before a 4-member Rivers House of Assembly was an affront to the constitutional provision. The judge subsequently restrained the Central Bank of Nigeria, the Accountant General of the Federation, Zenith Bank, and Access Bank from further allowing Fubara to access money from the Consolidated Revenue and Federation accounts. Still in Abuja, some alleged End Bad Governance protesters, mostly minors and looking malnourished, were brought before Justice Obiora Igwatu to be arraigned on a 10-count charge bordering on treason, intent to destabilize Nigeria, and inciting mutiny by calling on the military to take over government from President Bola Tinubu, among others. They were arraigned in 2 batches, following their arrests and detention during the August 1 to 10 nationwide protests in Abuja, Kano, Kaduna, Zaria, Katsina, Gombe, and Jos. They all pleaded not guilty. Justice Igwatu granted them bail in the sum of 10 million naira each and 2 sureties in like sum. Before their arraignment, some of the minors slumped in court. They looked malnourished and their condition was said to have deteriorated following weeks of being detained in custody. Eyewitnesses described the scene as harrowing, with some lawyers rushing to assist the youths, who slumped after being asked to enter the dock. The prosecution was said to have temporarily withdrew the charges against 5 of them to allow them receive medical treatment, after which they may be arraigned. In another case involving Godwin Emefiele, Justice Deinde Dikpeolu of the Federal High Court sitting in Lagos ordered the final forfeiture of the sum of $2.045 million, 7 choice landed properties, and share certificates linked to the former governor of the Central Bank of Nigeria, Godwin Emefiele. Justice Dikpeolu ordered the permanent forfeiture of the money and the share certificates of Quinsdorf Global Fund Limited Trust, after holding that the former CBN governor or any other interested party did not contest same after the initial interim forfeiture. The court also forfeited the 7 choice landed properties on the ground that the former CBN governor Emefiele was not able to connect his lawful earnings from Zenith Bank and the Central Bank of Nigeria to the acquisition of the properties. All the assets are to be forfeited to the federal government of Nigeria. And we round off in Lagos, where a former secretary to the Central Bank of Nigeria, CBN, Mr. John Oga, has told Justice Raman Oshodi of the Lagos High Court that his former boss, Godwin Emefiele, listed his niece as one of the beneficiaries of funds from an account allegedly operated on his behalf. Oga, who is testifying as the 6th prosecution witness, made the disclosure while answering questions from the counsel to the Economic and Financial Crimes Commission, EFCC, Senior Advocate of Nigeria, Rotimi Oyedepo. Oga told the court that he is aware that the former CBN governor once instructed the 5th prosecution witness, an account officer with Zenith Bank, Ifoma Ugbonnaya, to send funds to the account of his niece named Hannah. Emefiele's counsel, Senior Advocate of Nigeria, Olalekan Ojo, raised objections to this line of questions and queried the relevance of the testimony as Hannah's name was not mentioned anywhere in the charge. He insisted that it was an attempt to introduce sensationalism into the matter. Justice Oshodi has adjourned the case to November 28 for continuation of trial.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shoyele. Thank you for watching and see you next week.